Thank you so much for joining us at this meeting. Very delighted to introduce Professor Colleen Flood. Comes to us all the way from Canada. She is the Dean of Queen's University, Faculty of Law, and an expert in AI. I'm also very pleased to say that we have collaborated together under Colleen's leadership on a CIHR grant. So we had the first round, and also very happy to announce that under Colleen's leadership, we have managed to secure another round of funding. So so many congratulations, Colleen, and of course to the team as well. So so as we know, the Therapeutic Goods Authority the TGA has recently done a review of the legislation, and the assessment was that although our legislation itself is generally fit for purpose, there are certain aspects that will need to be reviewed. So we are to anticipate some changes that will follow. I think it's a wonderful opportunity to learn from experiences elsewhere. In fact, the TGA itself indicated that that would be very much its intent and desire. So I think it's in keeping with that spirit. We're very delighted to hear from Colleen. I'd like to take this opportunity, of course, to thank our colleagues Shir and V, as well as the ops team, for helping to put the event together. Our student assistant, Joel and Jade, thank you so much for your help as well. And so with this, Colleen, the floor is yours. Thank you so much.
All right, so we're just going to get the slides up, and I just want to start by thanking Calvin and Stephen, the Dean, and the Health Law Group for inviting me today. It's a great pleasure to be here. So as you heard, in recent years, I've been okay, we want. Second. Okay, there we go. All got that. Need a view presentation.
Sure, I think you click OK, where it says meeting's being transcribed, and you'll have slideshow come up.
Yeah. Sorry, I can't see.
No, it's hidden away. Not on the left.
From the beginning, at the on the far left. Yeah. There we go. Lovely. Hopefully. Yes. No, I don't want all my notes up there. So anyway, I'll just keep talking while she's figuring that out. So we have been working on this grant about health AI and whether or not, in this case, everyone's transfixed with that. Look at me. Okay. Whether or not the governance and the laws that we have in Canada are sufficient to actually regulate for the challenges. So that's been the project that we've been working on up until this point. So those in the room, you know, I'm sure that you are actually familiar with what AI is, but let's just start there because some people aren't. And to be clear, it is a very heterogeneous thing. It's not one thing. It's many different kinds of things that fall inside the rubric of AI. But you know, long story short, I guess the goal or the, you know, how we commonly think about it is that it can mimic human intelligence, right? It can actually make decisions in conjunction with a clinician. So with a doctor, a nurse, a pharmacist, and in some cases may even substitute for the decision-making of a nurse, a clinician, a pharmacist. So that is the sort of idea of it, that AI can actually, you know, really mimic human intelligence. And so in Canada, we really are hoping that, and I'm sure this is somewhat true in Australia, but perhaps not to the same extent, that AI will have a transformative effect on the healthcare system in big and small ways. So we have, you know, scribes. We still got a problem there. We have evidence that in Canada we're spending, like family doctors are spending 19 hours a week on just doing the paperwork. So dealing with electronic medical records and filling all of the stuff in. And those of you who work in the hospital sector probably know how aggravating that is for clinicians. So 19 hours a week, even if we could just save a little bit of that time through using AI, it would be, completely transformative to the healthcare system. If it meant that, for example, that some of the 6.5 million Canadians who don't have a family doctor could actually, the family doctors could actually take more of them. So there's a lot of pressure coming from the healthcare system side of things to really move on AI. So I am a bit of a AI optimist in this regard, and I wanted to show you, if we ever get there, that's okay. Some of the transformative examples of health AI out there. So, for example, in the global south, we're seeing evidence for TB screening, for example, in India, showing that AI is able to detect up to 13% more of the TB cases than humans are. And obviously, that's a very good thing. Okay. So, and then we are seeing other examples of which I can show you if we, okay. All right, terrific. It's always the way, isn't it? Technology, fabulous. And then it doesn't actually. So here's examples of the TB. So here are some examples from, I guess, more of the global north. You see sort of stroke diagnosis in the UK. AI software reads stroke brain scans twice as accurately as doctors, quickly estimating stroke timing and ensuring prompter treatment. So there's all sorts of evidence about the transformative potential of health AI. So there's a lot of hope around this. Here's an example closer to home for me. So Unity Health is a big academic sort of set of hospitals in Toronto. They're quite aggressive on health AI because they have, helpfully, an in-house counsel who's fairly bullish, right, about the risks and the benefits and moving forward on it. And so they are really coming up with a lot of innovation quite fast in that context. Here's an example of using predictive AI tools in ICU units. So in an ICU unit, lots of bells, whistles, things coming at you. As a clinician, it's actually really hard to kind of process all that as a human. And the individual in front of you, maybe it's a kid, this might be the first time you've ever had a kid that's actually at risk of stroke. You don't know that, right? Because in your sort of history, this is a very unusual, rare event. But in the history of kids in ICU, it's not that unusual or rare. So using big data, you might be able to predict which of these kids are more likely to have a stroke and intervene. So to monitor them earlier, to watch them earlier. And they're doing this in this ICU unit in Unity Health, and they are seeing, and they just published this, mortality drop of 26%, right? That's an incredible result of an ICU unit where a lot of people die. So those are some of the great things that are happening. But of course, there are lots of concern, right? There are lots of wonderful potential. But how do we make sure we grab the potential and eliminate the risk? Because all you hear about is potential, innovation, economic benefits, and not enough really about the risks and how law should respond to those risks. So that's what we've been working on. And there are a bunch of issues like consent and other things. Today, I'm going to talk mostly about safety and quality, and a bit on liability, and then how it sort of links to privacy issues as well. So that's where I'm going to focus today, but I'm going to talk about some of these other things and show how they're actually all kind of connected up in some ways. So bias is one of the bigger issues that we hear about as a risk factor. So bias can occur because the programmer themselves is biased. So they program it in a way that reflects their underlying gender, racial kinds of bias, and that can affect the result. And that bias, like from a legal perspective, we often think about bias as resulting in discrimination. But in this case, bias can actually result in safety concerns, right? Like if you're trained on a data set that is all about white men, and then you're applying the AI software to older women, you might get the wrong results. You might diagnose them incorrectly, and you might apply the wrong treatment plan. So, I think when we talk about bias and discrimination, lawyers' brains automatically go to discrimination, equality, and these kinds of things. But this is actually just a pure out safety issue here. So the training data is relevant here, as well as the testing data. Like, how is it tested? As well as the bias of the individual programmer. So all of these things can affect this. So here's an example of the racial bias. You've probably seen this result. It's very disturbing. So a widely used hospital AI tool for healthcare management was found to be systemically undertreating Black patients. And the reason it did this was because it looked at the healthcare expenditure on Black patients and said, oh, it's $1,800 less for the same healthcare needs, like for diabetes or for cardiac care, et cetera, et cetera. They just must be healthier, right? That's why we're spending less money on them, as opposed to, well, actually, this is just systemic racism from the get-go about undertreatment, underfunding, and all of the things, right? And so once they figured that out, that that discrimination was resulting in that underservice, like the amount of care that the Black patients received tripled. Right? That's a really serious, poor outcome from a bias issue. So you see why we need to attend to this from a legal perspective. And it's not just a, oh, well, kind of an issue, right? So you probably heard this thing quite a bit, garbage in, garbage out. So poor data, poor training data, poor testing data can result in poor AI in the sense that there are safety and quality issues. So this is a big issue in Canada, and I think in Australia as well. Discussions of the need for better data to train AI on. And this is kind of a catch-22 for us as lawyers because, of course, munching up oceans of data also raises significant privacy issues, right? So you've got this kind of, on the one hand, we want more data so we can try to attend to the bias issues. On the other hand, providing oceans of data raises real secure issues around privacy, particularly for historically marginalized and vulnerable groups who are often not that keen on the provision of their data because in the past it has been used against them in horrific ways. So, they're not that, in Canada, Indigenous peoples are not that excited about handing over their data because they're easily identified actually, right? Because they're a relatively small population. So you have this problem of garbage in and garbage out, but it relates to the privacy issues as well. And I think the other issue that we have is that there's kind of this idea that we have to have perfection in the data sets. So discussion that we have to have representative data sets, which again goes to, okay, so we need an ocean of data. Well, first of all, we're never going to get that. And secondly, there are privacy concerns around this. And thirdly, we might not need it. So for some things, like I mentioned, the bias against Black patients in that US study, but for a number of things, it makes no difference whether you're a man or a woman, whether you're older or younger, right? You don't actually need a representative data set because, the physiology is the same, right? You're not going to get a different outcome. So it really depends. And what you really need to know is that once I have the AI tool and I'm deploying it out into the Australian healthcare system, that's when I need to know what's going on, right? I need to know how it's going to work in different parts of Australia, in rural and urban, and in different subgroups. I need that data to inform and improve the tool. right? That's what I need, not perfect data set back here. Because even if I had a perfect data set, once I actually deploy it in real life, much like pharmaceuticals, right? Once you actually put it out there, it's a different story, right? From how you might have trained it or tested it. So it's that post-market data that is really needed, and where I'm sure the therapeutic agency is heading towards as well. So the issue of privacy I've already raised, and and I think it's the same in Australia as it is in Canada, but you can correct me. Like the big protection that we have for people in Australia, which country am I in? In Canadian law, privacy is consent. Like I consent to the use of my data. Yeah. Well, I'm a dean of law. I sign these things all the time, right? Click and swipe, click and swipe, click and swipe. I want to get access to this, click and swipe. Do I read all that crap? No. Does anyone? No, right? So this consent as a protection is pretty much a mirage, I think, these days. So we have to really rethink this. The other protection that we have is de-identification, right? The data is de-identified, and now I can use it for research purposes. So what we are seeing in Canada is that it's de-identified and then it's being sold offshore, right? So the scribes are picking it up, the vendors of the scribes are then de-identifying it, and they're selling your data to whomever. No protections there once it's de-identified. So again, like these protections that we have in law are not actually really helping us, because de-identification isn't much of a protection anymore with AI, right? You can, if you're desirous of this, re-identify patients. Like it's not that easy, but it is possible to do, right? So that's a real concern. I'll jump over this. So the other piece of this, particularly I mentioned at the beginning the definition of AI. I should have also mentioned machine learning. So this is the idea that the machine can actually learn in real time, and that is good, right? We actually want it to get better at what it does. We want it to get better at predicting. We want it to get better at treatment options. We want it to do all those things. So that's terrific. However, it might not get better. It could change in a way that isn't good, right? So hopefully it's only getting better, but if it's getting worse, how do we know? How do we tell? How do we fix that, right? And you can imagine that if it's deployed and becomes a standard of care, so imagine it's an AI tool used by radiologists all across Australia. That's a bit of a concern if it goes off piece and starts misdiagnosing or underdiagnosing. It could take quite a long time for us to figure that out, as opposed to, one random bad radiologist. There always seems to be one somewhere in some jurisdiction who's, doing a bad thing. That's one radiologist. Right? So that is something to really consider about. So this problem of that the machine learning tool, if it's adaptive. So what happens in Australia right now is that these adaptive machine learning tools are not able to be approved currently in Australia. Canada has moved to allow them, and the big push here is to allow them as well, right? But the $64 million question is then, how do you regulate and monitor these suckers? That's a technical term. Over time and space. How do you do that? How is the regulator actually going to do that in a way that you can trust that that these tools are safe? Right. So that is a significant issue. We talk about the black box of algorithmic decision making. And I put this here because I was thinking, it's not just a black box of algorithmic decision-making, but I think it's also that we well, when I was a kid, and I was thinking when I grew up, there would be adults in charge who would run the world and it would all be safe and good, right? And it turned out that it's not. I think we might generally agree with that there aren't adults in charge and it isn't safe and good. And I think with AI in healthcare, because healthcare is a very regulated space, people assume that it must be safe. Otherwise, the doctor wouldn't be using it, right? But the doctor often has no idea how it's actually working, how it's actually functioning. And as we see, there's very little real regulation of health AI currently. Right? So we're left to the common law, we're left to existing laws to respond. So I think that's a problem, is that patients, clinicians might not be wary enough, right, about the actual risks here. So I'm going to focus a little bit on clinicians and why they need to be particularly concerned here. So a lot of you are in law school, so you know the basics of tort law. But let me just say that with the duty of care, usually that's pretty a slam dunk between a doctor and a patient. We don't really usually have to argue too much about that. A duty of care is found. But breach of the standard of care, what's the standard of care? You know, so it's usually in Canada kind of what a reasonable physician would do, sort of what is the general standard in the profession. Now, we see here that with the use of health AI, that's evolving and changing. Right? Some people are front runners and they are using health AI and they're taking some risks, because if it doesn't work very well, the court might find that, well, you went too far. You should have used your own judgment. You shouldn't have relied on the health AI. But by the same token, like when I talk to physicians, they're all like, yes, because they're like, I don't like this stuff. I'm like, well, you will be in trouble too in the not too distant future. Once it becomes a sort of standard of care to use health AI in this diagnosis or this treatment, and you are sitting back and not using it, you will be in trouble, right? For not applying the standard of care. So it's this evolving space right now. And I think that makes it quite uncertain for doctors. And here I would say it's really important that the regulators get involved and start explaining what they think is the standard of care and the use of AI. So those kind of guidelines can help shape the liability discussion, right? So what is the main, I've forgotten, sorry, the main name of the physician regulator here? AFRA. So they would need to be, and maybe they already have, started publishing guidelines about the use of health AI, but that is really important. Like in Canada, we've been publishing guidelines around the use of scribes. And that has been really helpful to clinicians to know when they should be using it and not using it, because they're like, well, I don't know, which one should I use? Like there's a gazillion of them. Some are worse than others. Some are really problematic. And so they've had this sort of quasi-regulator come up with a list of scribes that doctors can use that are sort of privacy approved, you know, all of that kind of thing. So that's something to think about. So, you know, as we think about, I'm just going to check what I wanted to say here. Yes. So in terms of liability, though, there's many, many different things that could go wrong with health AI. So I mentioned the training data, the testing data, right, the use of data. It could be problems with the, you know, however, where the software is actually implanted in sort of the ecosystem. There could be a problem in the larger ecosystem. But long story short, the complexity of assigning liability here is significant, because as between the programmer, the manufacturer, the clinician, the hospital, it's going to be really difficult for a patient to identify the particular problem, right? Who did what that was bad enough that liability should attract, when it's this kind of opaque, sort of series of interconnected relationships. And as you probably know, at least in Canada, is really an uphill battle for patients to bring medical malpractice claim anyway, or a product liability claim. So either of those two things are already incredibly difficult for patients. So to imagine then that the common law and a product liability or med mal claims are going to be the protection that we need, I think is a fairy story, right? So to your question then, should we have more proactive regulation? Clearly to me, the answer is yes. So I talked about the evolving standard of care, and I think at least in the law school, we probably have this same sort of story here is what do we know for sure? Only that we want to adopt it everywhere as fast as we can, right? So everyone's on the band roll about this. And, sometimes I feel a bit like in a minority of a couple of people sticking their hand up to say, look, I can see the benefits. There are many, but the steamroller towards it without real reflection is deeply problematic. And that steamroller is coming because of chaos in healthcare systems post-COVID, tariff wars and the desire to be at the forefront of economic development and innovation, right? So that is really driving this as well. And then from the industry itself, like I work with a lot of clinical innovators who are amazing, but they really have the ear of the regulator. They are the ones that are in there with the regulator all the time, right? So to me, that's in economic terms, we call regulatory capture. They are captured. The regulator is, more worried about how the innovators feel about the regulation than the public interest. And I'm not too popular when I say that, but it is, I think, a real concern. And it's not to say anything negative about the individuals involved. It just is a systematic kind of effect, right? Like no one means to make bad decisions, but one can see over time, like if only those who are regulated are at the table, then there could be an impact. Yeah.
I was going to say, what are your thoughts on the impact on the protective ability of approval of this software and AI as a medical device too?
Yeah, I'm coming to that in 2 seconds flat. So yeah, great question. So what we also see, and clinicians themselves are really part of this as well, and we see this in the regulations, as to the extent we have regulation of medical devices, there's less of a hard look at medical devices with AI if there is, quote unquote, a provider in the loop, right? So if the clinician is part of it, then somehow that is meant to ensure the safety of the product. So I think that is bumble jumble because of the black box problem. So unless you are a very, very rare physician, and I do have friends who are physician computer scientists, but even they cannot really know how these things are reaching their conclusions and sort of go backwards to say, okay, well, it's made a mistake somewhere, so I'm not going to follow its advice. Right? How is a physician meant to do that? How's a nurse or other clinician meant to somehow involve or step in and say, it's making a wrong choice? Right? That is ridiculous. And yet that is the mantra we hear everywhere, particularly from folks in the humanities, like we just need to have a provider in the loop. The human is going to save us. Well, the human was making the mistakes before. That's why we're using AI, right? So how is a human going to save us? Unless it's something really obvious, like a zebra instead of a horse, right? Or describing the patient in front of you as 85 years old and they're 15, something like that. Right? Maybe the healthcare provider could pick it up. But, the other problem is if you've got the provider in the loop, they might be like, well, I trained in 1995 in Monash Health and I was taught this. And so the AI is wrong. And so they override the AI when the AI is right. And so you've got a bit of an issue there. So this provider in the loop stuff, not so much, I think. This is an endless debate about this. And I think, again, clinicians are desirous of this because they want a job. right? So they're worried about AI replacing them. They want to control it. They want power over it, which I completely understand. Same with lawyers, right? We want to own it. We don't want it to own us. But there is no free lunch here. If you're going to hold yourself out as controlling the AI and responsible for the AI, then you're going to have to take ownership of that, to take on the liability for it. And so this then goes to your point, like if we back that up, that makes it even more important to have ex-ante regulation to say that these medical devices with AI are safe, right? As a clinician, I should know that there's a reasonable chance that this thing actually does what it says it should do, right? Because I'm holding myself out between it and the patient. And I think that's something really serious to think about. Also, you know, that I'm also telling them to trust me. So you come to me, I'm your doctor. Trust me, trust this machine. You're giving up your data. Like, do the clinicians know where my data is actually going? Because it's saying, you know, we train patients to trust their doctor, but I am also indirectly telling them to trust the provider of this AI tool. And I think that's a really interesting question. Meanwhile, those of us who are in the law realm are really, really busy writing contracts to try to download all the liability away from our clients, the vendors, the manufacturers, right, onto the willing backs of the clinicians. Because they're sticking their hands up saying, we're the provider in the loop, we're the learned intermediary, you know, we're in there. And they're like, good, right. We will just make sure that you have all the liability here. Who's reading these contracts? Right? Especially if you're just a wee GP in the middle of nowhere, picking up your scribe or whatever it is to use. Are you actually really understanding what you're doing? Again, there really needs to be a role for the regulatory colleges and the medical associations to help clinicians with this. Just leaving them to caveat emptor, like market, you know, buyer beware, is a bad idea, I think. So these contracts are really important. And again, I think all go to show why clinicians should be really worried about the regulation of the safety of health AI. And clinicians should be calling for the TGA and similar regulators to properly regulate these health AI tools. So why we should have protective regulation before the harm happens, right? So I've tried to make that case for you that we need to do this to make sure that people are not harmed, patients are not harmed, clinicians are protected as they're using health AI, that they know that it's reasonably safe as they're using it, because otherwise, why would they? You know, like you're just going to freeze it up. I also think I try to explain to my friends who are innovators, often clinical innovators, look, folks, you know, we just need a couple of really horrible things to happen, and then it's going to come down on you like a ton of bricks, right? We'll see perhaps over-regulation, which some might argue we see with pharmaceuticals, right? So much layers of protection in there that sometimes it feels like forever before you can get a promising drug onto the market. Well, do we want that? Well, we used to have a free-for-all with pharmaceuticals, and then we had some terrible, terrible things happen to patients, and now we got what we got. So that usually kind of makes people pause a little bit and reflect on, okay, so it's maybe potentially good for the industry to only let the good players in. And by the good players, I don't mean the massive players. So it's got to be effective, efficient, not regulation, rhetorical regulation for the heck of it, right? It's got to really work and not overburden sort of small and medium-sized players, particularly clinical innovators who don't, you know, they're not big, massive companies. And I think we've seen the impact of having massive companies in the sort of IT space. And we don't want that in healthcare. So it has to be flexible, adaptable, not OTT regulation, careful, adroit regulation. So this is, in Canada, we had an attempt, it was to regulate all of AI. It was called the ADA. It was terrible. It was basically nothing. Sort of had some words on paper, blah, blah, risk regulation. Everyone complained about it, the process, what was actually said, and it died on the order table before the last election. Justin Trudeau lost the last election. Now we have Prime Minister Carney in place. So the question is, will we see some new version of this or not? So will we have sort of overarching AI regulation more along the lines that you see in the EU, or, you know, Canada, maybe a bit like Australia, where we're sort of bit between the US and Europe, depending on the weather, right? So we sort of muddle along in the middle, trying to find the right sort of space here. And I think everyone's horribly confused on this one. Should we go for the EU, who seem to be our new friends these days, or should we just accept the fact that we're about to become the 51st state and go all free market a la the US? So this, we're still waiting to hear. So when I talk to innovators and clinical innovators and sometimes even regulators about the need for regulation, I think this is what they have in mind, that regulation is going to be so stupid and so impede, you know, the innovation that we shouldn't do it. And the innovators are really resistant to it. They say, we know more about the industry than the regulator. You can't regulate because we know what we're doing. You should leave it to us. And so I think they see it as this. So when the motor car first came out, it was a requirement that a person, basically a man, walked in front of it no more than 5 kilometers an hour, waving a red flag, right? Like, watch out, dangerous, dangerous car, right? So I think that's how it is somewhat perceived. And obviously we don't want that. Or, you know, we know we're going to accept some risks here because there are benefits. So it's a risk-benefit trade-off, as it is with motor vehicles. They are dangerous. They do kill people, but there are so many benefits from it, we let it go. But we've also seen that with adroit regulation, like safety bags and speed limits and all that kind of stuff, we can really, really attenuate the losses, right? So I think that's not a bad one. So your question was about medical device regulations, and I know that many of you are interested in this because of what the TGA is doing. So all countries, most countries in the global north anyway, have medical device regulations, and all countries have included software alone, so AI software, to come within the ambit of the jurisdiction of medical device regulation. So it doesn't have to be a cochlear implant or any kind of hard device. It can just be software. And it falls then, if it's intended for a medical purpose, it falls within the ambit of the regulation of medical devices. Now, in Canada, that's a really, really good thing, because usually in healthcare, it's a hot mess because we have 10 provinces, 3 territories. Ostensibly, they have jurisdiction over healthcare. So, you know, if you get your medical degree in Ontario and you want to go to BC, it's a big drama, So we have different privacy legislation, federal, provincial. Each province has its own. Each one does something different on public and private. Each one, it's a hot mess. So, well, that's a bit harsh, but it's difficult. It's, you know, it's good for lawyers, right? We do okay with this kind of thing. But medical device regulation is federal. Now that's interesting for us in Canada, because if we can figure this out and we have one-stop shopping at the federal level, that would actually be an incredible thing, right? So really, really good thing. But there are a bunch of problems which I've listed here. So for example, I mentioned the human in the loop issue. So reliance on that as a safety mechanism, as I've said, I don't think that's much of a reliance. And as with Australia, up until very recently, adaptive machine learning tools, so the ones that get out into and in their use, evolve and change, were not able to be approved. So the idea was, well, it's not the same thing anymore, right? Like, I've approved it here at point A, and then at point M, it is actually a different product. It has different features because it's evolved and it's changed. So you actually need to come back and start again and get all of the approvals. So, so for a while they were saying that you can't actually even do it under the framework. Then somehow, I'm not quite sure how, but they got insights from other jurisdictions to say, actually, we think we can. We don't actually need to change the legislation. We don't need to change the regulations. We think we can just approve these things. And so they have moved to do that, moved to approve this adaptive machine learning tools. So that's good and bad, right? So good because some of, we actually want machine learning tools, adaptive machine learning tools. We want them to evolve. We want them to get better. If they're fixed, they can actually deteriorate over time and space. And that's not a good thing either. So just, fixed or adaptive, just having fixed is not necessarily a good thing. But adaptive, so it changes over time. And when deployed, that can be good if it's getting better, but it could be bad if it's going off piece and doing different things that we might not want. So how do we deal with that? So how Canada has dealt with this is to release these guidelines, pre-market guidelines for machine learning enabled medical devices. And long story short, what this provides is that as part of the approval process, if you have adaptive machine learning, you have to, well, the have to part is the question because it's all in this very sort of you may or you could. It's very sort of loosey-goosey. You may provide this pre-controlled change plan. So the manufacturers themselves, as they're applying for approval, they have to put in a plan to show how they will, with certain boundaries, things that could change within a certain scope, that they will change them in real time out in the market, out in the healthcare system. So it's not like they're going to approve everything. Like you can't change it so that its basic nature is different. But within a sort of band of reasonableness, you'll be able to simply say, well, this is all being foretold by the pre-controlled change plan, and we have this in hand. The big question is, how will this be monitored? How will there be regulatory oversight of it? It really relies on the manufacturers themselves reporting any problems. And of course, why would you do that? Right? Because if you report the problem, then you might have to go back to the drawing board and get reapproval. And so that's kind of the worst thing. Right? We don't want them to be concerned about this because actually some of the stuff might be quite easy to fix, really. Right? Like a tweak of an algorithm is a lot easier than pulling a whole drug off the market and having to start again, right? So this is where I think that with the work that Calvin's going to be involved in, we want to try to figure this out. How do we approach this? How do we see the oversight of medical device regulations, particularly machine learning and generative AI? So it's evolving and changing out in the marketplace. How the heck do we regulate that? Right? Because the old school regulation is kind of green, good to go, see ya, bye, or red. Nothing, right? You don't get past go. But what we really need here is kind of flashing amber all the time. Okay, come to market. We'll let you in. But we need to be able to monitor what is going on in real time across Canada. So I kind of think it's almost exciting, the potential for that we could actually have this really significant public health surveillance going on, so that we could see if things are going off piece and correct them in real time. But I mentioned, the federal provincial problems in Canada, that the provinces control the health data. They aren't really that keen on sharing it with the federal government. So we have quite a mission if we're going to get to a place where we're going to have this great data set that would actually really help inform the safety of these machine learning tools. But Canada is like one of really some of the Geoffrey Hinton and other really incredible AI innovators all came from Canada. So Canada was at the forefront of AI innovation, and we've sort of fallen behind because we haven't been able to kind of push it forward. And so that again is leading to this, oh, well, we just have to let it all run. But if we could actually test out different health AI in our public data set and say, you know, this health AI works really well in these subpopulations in these areas, that could be a really, really powerful thing for the industry, right? As well as for the safety of patients. So that's that. You know, I've got a story about this, but I won't tell it right now. So that's my sort of hope, right? That Canada could get there. I think, you know, it's really important that we have moved on the machine learning front, and I'm excited for that. And I know that Australia is considering it as well, but it's more complicated than just letting it go, right? What's the plan for actually making sure you're going to have monitoring and surveillance? So the FDA in the US, right, they have this pre-controlled change plan. Canada's gone along with that, right? So just because others are doing it, it's like lemmings running over the cliff, doesn't mean it's the right thing to do. But, you know, I do think we want machine learning tools, so how to regulate them, right? So I sometimes think about this and I don't know how to solve it yet, but that's why we got this grant. But, you know, how can we regulate? This is the sort of innovation is so incredible. How can we think about regulating, innovating in regulation? How do we do that? That's not just a pass. That's not just a, you know, do what you like. That's not much of an answer, right? How do we get better at that? So for the docs, I say here that clinicians need to be careful about the use of AI tools trained on data that doesn't reflect the patient in front of them. Right? So you do need to know as a doctor what the data set is that the AI tool has been trained on. Ideally, I think there would be some notification to you as a clinician about the data set and any gaps in that data set so that you are aware, right? So you can bring your brain to the table and say, okay, well, I'm willing, you know, I'm going to explore the risks with the patient. This hasn't been tested on babies or pregnant women or whatever, but I think it's going to be reasonably safe, so we'll explore that. Liability will largely fall on the healthcare providers because of the contracts and all of those sorts of things, if there is liability to be found at all, right? So not using AI as well may not be a protective shield for too long if AI becomes the standard. There are significant issues related to the use of third-party data, patient data and third-party applications. So I mentioned like the use of scribes, the AI data, owners picking up that data and then de-identifying it and using it for other things. So I think there are some really significant informed consent issues to be dealt with. Self-regulating health associations, medical associations, regulators have a role to play in setting standards. I think, you know, this idea we're just going to leave the doctors, nurses, and so on, pharmacists out there on their own in the cold to figure this out is really, really silly. So this is a more soft law intermediary step, but I think it's a really important one to move on. And Health Canada and other regulators need to make a paradigm shift in how they approach regulation of rapidly evolving technologies. And this really goes to the issue of post-market surveillance. So how is that going to happen? We've really struggled with that in pharmaceuticals. This is an even bigger issue. The rate of AI applications coming to market is enormous, right? And of course, wow, we have to innovate, so we just more and more and more and more of them, whether they're good or bad, is an issue. So there we go. That's it. Thank you for listening.
Thank you so much, Colleen. Oh, thank you. Thank you so much. Yeah. So excellent presentation that highlights so many similar challenges that we have in Australia as well, in terms of the Commonwealth, state and territory kind of divide and challenges of that, in thinking about how regulation could be more responsive, rather than just our core agnostic and risk-based kind of approach, which may not speak to a number of issues that Colleen has highlighted very well. And And also it's difficult to think about in the Australian context, this provider in the loop, how do we even get going with that? Because our regulatory setup is essentially or primarily focused on manufacturers and sponsors only. So yeah, so it's very difficult to see how clinicians, for example, even patients could have feedback into the system.